I appreciate you coming by today. I kind of look at today as a chance for us to do some brainstorming, going over some issues that we're seeing out there. I'm Ned Hale, and this is Hall of Famer Annette Haber. Do I sound like Joe Buck? Doesn't he always say that? Whoever he's with, Hall of Famer, right? If it's Troy Aikman, if it's John Smoltz, he always says Hall of Famer. But in this case, we'll call her the Hall of Famer, Annette Haber. We're both lawyers. No, we're not married. My wife's over there.
Thank you for starting off with that.
Yeah, we're not married. We are friends. We're not in practice together. She's with Jones, Haber, and Rawlings. I'm with Hale Law. And so really I thought today we just kind of had, this is really the inaugural broker coffee talk. I'm really glad with the turnout here. I'm sure a few more people will be coming in. The way we kind of envision this is a way for us to sort of go over, like I just said, some hot topics, some things that you're seeing going on, some things that we're seeing going on. And I'd also like to talk about, as always, and that's avoiding liability and understanding what your role is in terms of liability. So that was kind of how we have a little handout here that we're going to go over in a minute. Annette, do you have any introductory remarks you'd like to make?
You did fine.
Okay.
We're not married.
We're not married. We are friends, I hope. So anyway, go ahead. Let's just take a look. I think, and folks, this is, you're brokers, you're sophisticated, you're experienced, you've got, the highest license you can as an agent, to sell real estate, if you will. And most of you have incredible knowledge that, quite frankly, the whole class could benefit from. We will benefit from. And so please, this is freestanding, freewheeling. Chime in whenever, ask questions, share with other agents. There's nothing, other brokers rather. Nothing wrong with saying, hey, are you folks seeing this? Here's something I'm seeing. But I wanted to start with what I always like to start with is liability, just to give you guys an understanding in terms of how liable you are for the acts of agents under you. If you look at page 1 of the handout, chapter 475 very clearly says, .25, you can be put on probation, suspended, have your license revoked if you have, page 1, failed, if a broker, that's you, to direct, control, or manage a broker, associate, or sales associate employed by you. So in case you think, well, my agent did bad, Brett can't do anything to you, you're wrong. The statute very clearly that says that you can be disciplined if an agent working under you does something bad. Hence, I think you should all take a pretty hard line when it comes to agents and their actions, and if they do anything you think is dishonest or wrong or fraudulent, keep in mind it could be you that is, if you will, gone after, for lack of a better term. Look at page 2 also, and you can be sued. Goodman versus Rose Realty West from 2016, page 2. This is where a buyer sued a salesperson and a brokerage, the company, right? Because for a tort where they did something wrong, it so happened that the real estate agent was also the owner of the property, failed to disclose things under Johnson v. Davis, and they dragged in. Now the brokerage, Rose Realty West, they hadn't proven that that company had done anything wrong, right? The suit really primarily was against who? The salesperson. And the broker said, hey, wait a minute, you can't drag me into this. You can't drag my company, not me, not the broker individually, but the broker's company, Rose Realty West. You can't drag us into this. We didn't do anything wrong. Look at page 3. The court said, yes, they can drag you in. They can drag your company into a lawsuit if they allege your agent did something wrong. So anybody who tells you they can't doesn't know the case law. If you look at page 3, it clearly says, where I've highlighted, I bolded this, a principal is civilly liable, you're the principal, for the tortious acts of his agent, which are in the scope of your employment, even if they're deceitful or fraudulent. Turn to the top of page 4. If the seller/agent, remember the agent was the one who did the bad things, the salesperson, they also happen to be the seller. Withheld material information, top of page 4. This was done during his work as a real estate agent to facilitate a sale which was in the interest of the principal broker who would earn a commission, meaning anything they do while they're working for you, as long as they're trying to earn a commission, exposes you to what? Vicarious liability. You've heard of the phrase, oh, I'm living vicariously. That's always kind of cute. Oh, I'm living vicariously through my son or daughter, whatever. Well, you can also be liable vicariously, and it's not nearly as much fun as living vicariously. So you can be dragged into a lawsuit if your agent allegedly does something bad. Not you personally, but your brokerage can be dragged in.
So let's role play a little bit. So if I'm mad, right, and my agent did really bad and I want to come see you as a litigation attorney, then how do you analyze who you're actually going to file the lawsuit against and why? Why don't you just file it against the real estate agent?
Well, I like Italian food, especially spaghetti, so I'll just throw a bunch of it against the wall and see what sticks. Usually we lawyers sue everybody we can think of, right? So I would just, in this case, the plaintiff's attorney sued the agent and the brokerage, and look at this on page 3. They sued the inspection company. It looks like they also, the top of page 3, you see all the defendants. The two agents, the realty company, it looks like they sued both realtors. So you're going to sue everybody you think you can, and let's see how it all plays out. So the broker said, wait a minute, you can't sue my brokerage. And the court said, yes, they can. Now, this doesn't mean they won the suit, folks. This means they can sue, right? So.
And so that means you count how many defendants you have. So how many policies are you getting copies of to see what kind of coverage there is?
That's
also
right, E&O, right? We have 1, 2, 3, 4, 5 different defendants that all are going to be presumably calling their E&O carriers. But is E&O coverage required by any FREC rule?
Let them answer.
Is it? No, it isn't. The E&O coverage, there's no law which requires E&O coverage. Many of you, I think, have it. Most of you probably do. But I know some brokers that don't have it. That own brokerages. They're like, no, I don't have it. So that's not required by any law.
So then if they don't have it, then what happens?
Then they either, now keep in mind, a company cannot defend itself in court unless it's small claims. So they would have to hire an attorney out of their own pocket to defend the lawsuit. Only in small claims can a principal of a company defend itself in court. And the vast majorities are not filed in small claims, so they would have to hire an attorney to defend themselves in court. If you don't have E&O coverage.
What does small claims mean?
Small claims is under $5,000. Disputes under $5,000. There you don't, but a common misperception is, oh, I'll just kind of wing it myself and represent myself. No, folks, only a natural person, a human being can represent themselves in court. LLCs and companies must have an attorney. And I've seen judges literally throw principals out of the courtroom saying, oh, I'm here on behalf of, ABC Realty. I've seen judges say, are you an attorney? No, you got to have an attorney. I'm going to give you 10 days to go get an attorney. So you don't have E&O coverage, you're going to be paying for a lawyer out of your own pocket. Now, what happens if you just don't respond to a lawsuit? What happens then? Oh, I don't have to respond. You get served. What happens then? Does it go away?
No.
What happens?
It doesn't evaporate?
What if you burn the summons in front of the process server? What happens then?
You lost.
You get what's called what? A default judgment against you, which is like a forfeiture of a football game. Some of the way some of these NFL teams are playing, they should have forfeited on Sunday. But anyway, yeah, so, you got to respond out of your own pocket or through your carrier. So
since we're here to try to protect them from liability, if they decide to burn that summons and they decide that it's going to hopefully evaporate and go away, and then they get that default judgment, what does that look like as far as collection purposes, and how bad can that really get for those that are thinking maybe they don't need coverage?
Well, the first thing you do is you go, even if you get defaulted, you got 20 days to respond to a summons. And even if you get defaulted and get a default judgment, still hire a lawyer to try to get it vacated, right, by the judge. And most judges will vacate them. And so that puts you back into the game. Take off the forfeiture. And then if you don't if you don't do that and you get a judgment against them, the judge is going to say you owe whatever they say because you didn't defend yourself. And then you're talking collections law, and then they can garnish bank accounts and that sort of thing. Florida is a debtor-friendly state. We're known to be a debtor-friendly state. Some might say deadbeat state. Depends on who you talk to. But, you know, they try to collect based on Florida collections law. The main thing they try to do is try to garnish bank accounts and or seize assets, you know.
And could that mean possibly the closing of their brokerage?
Absolutely. I've seen that happen. I've seen that happen, you know, with judgments against them. So moving on, page 5, there's another case. This is an article I wrote a while ago, well, just a couple years ago, on the Goichman case. Similar situation where this is a little different, similar in one way that the licensee, again, just by coincidence, was the owner of the property, page 5, but he was also his own agent. Most of you aren't going to hire a realtor, right, to sell your own house? Of course not. You're your own agent. They alleged that, the buyer alleged that failure to disclose material defects, Johnson v. Davis, you should be familiar with that case, and he said, the realtor now, we're not talking about the broker, just to give you an idea here, the realtor said, wait a minute, I work for ABC Realty. You can't sue me personally. They sued him personally. Mr. Goichman, he says, you have to sue whatever his brokerage was called, ABC Realty. And the courts, and he says, isn't that why people form corporations and LLC? And haven't you heard this? Well, haven't you had salespeople who say, okay, I'm going to set up an LLC or a PA, right, to avoid liability. That way, if I do something wrong, they got to sue my LLC or my PA, and they can't sue me personally? Well, they obviously haven't read the Goichman case. The Goichman case says, the court says, you can still be sued personally as a real estate licensee, as a salesperson, even if you work for ABC Realty. And to me, that would extend to even if he was Michael J. Goichman, LLC, thinking he's avoiding liability. So you folks can play this, you know, as I see agents all the time. Ned, I want to form an LLC, you know, in my own name, and that way, you know, John L. Smith LLC, and because that's what the statute says, you know what I mean? You can do business in an LLC in your own name. It's got to be your natural legal name, and you can do that. I say, why? Maybe for tax reasons, none that I can think of, but you're not limiting any liability. You may think you are. Somebody who didn't know what they were talking about might have told you could lower your liability, but they obviously didn't know this case. So you're personally liable, folks.
Can you elaborate on that? I hear that all the time.
They're wrong.
C versus PA. So what's the point?
There is no point, unless your tax accountant tells you there's a point.
Just for separation of assets?
Yeah, maybe, but not really, because you're still personally liable.
So you can sue both?
Yeah.
The LLC and you personally?
That's what I would do.
Let's expound upon that, though. What about the CPAs who form the entities for the agents?
What about
Or
them?
the agents that go and try to form them online by themselves? Do you have an opinion on that versus coming to an attorney and having an attorney set it up?
Don't waste your time or money. You can still be sued personally. Okay, you think you're reducing liability, but according to the case law, you're not. You're not reducing liability. You can be sued personally. Basically, that's what this case said. Now, again, is there another case that says something else? Maybe there might be. I'm telling you, this is a recent case from the 3rd DCA. If they allege that you personally participated in some sort of tort, you can be sued personally. Yeah.
So if Joe Smith LLC is sued by Annette Hale, because you're an Italian spaghetti fan,
Yep.
so you're going to sue Joe Smith, and you're going to sue Joe Smith
You bet.
LLC.
Yep.
Does that mean Joe Smith operating as Joe Smith LLC is really kind of duplicating his defense budget? Could he potentially be defending both Joe Smith and...
As a practical, yes. But as a practical matter...
Devil's advocate kind of way of looking at it.
As a practical matter, though, any lawyer that Joe Smith's going to hire is not going to charge any extra for defending both the LLC and the company.
Really?
Would that be you? Would you write that down? You heard it first.
I'm just telling you, every lawyer's different. Every lawyer's different. There are some fair lawyers in town. There are some outrageously priced lawyers in town. And the longer I'm in town, the more lawyers I see, right?
Like a real.
Yeah, right. It's getting to be the same. I mean, I moved here 20 years ago, and it was like, wow, there's not a whole lot of competition. Is it competitive now? Extremely.
Especially with the market the way it is right now.
Exactly. There's new ones popping up, new lawyers popping up every day, which is good for consumers, but it's also bad for people who don't want to be sued, because a lot of these young Turks coming out of law school, out of Ave Maria particularly, they're looking to sue somebody. Why not one of you? Why not one of you? Got to make a living.
I would like to call them fair versus unfair lawyers.
There you
How
go.
about
That's a nicer way of saying the same thing. So anyway, I just wanted to point that case out. Again, that doesn't mean that if somebody is sued personally, you're not going to argue some other way. What is the law? What is the law? The law is whatever the judge in your case says it is. If you've been divorced like I have, believe me, it's whatever the judge says it is. All right? That's the law. I mean, that's a cynic's view, but at the end of the day, unless you want to appeal, you got to go with whatever the judge
But you have
says.
the money to appeal.
How much are appeals?
Very expensive.
Yeah.
And then you've got to get all the transcripts.
Especially if you find an unfair lawyer to handle the appeal. How much? 10 grand?
At least.
At least 10 grand to
10
appeal.
grand.
So any decision you get that you don't like in court, at least 10 grand to appeal it. And 30 days, you got to file you're under the gun, you got to file an appeal within 30 days. So you don't like a decision from a judge, you can appeal it, pull out your wallet. Judges have a lot of power everywhere in America. And this little town is no exception.
And most time, that's not something your lawyer is going to put the funds up front to
No.
take care of the appeal. That's all coming out of your pocket.
Absolutely. I don't know of any lawyer that will, on something like this. How about on a contingency? Will a lawyer take any fights like these on contingencies, Annette?
I absolutely highly doubt it. How's that answer? I absolutely highly doubt it. Because would you? I mean, I don't
Never.
litigate anymore.
Never.
There you go.
But you've got folks in your office that are under you, and do you tell them, okay, take it on a contingency?
I'm nice.
Can we get your business card?
I'm nice. You know, you have to listen to what the customer and client's saying. You know? So, absolutely, I don't know.
Maybe so, she said. So I got some business I can send you. If you're going to take something like this on a contingency, I think I got some business I can send you. Most lawyers will not take real estate disputes on a contingency. That's just car wreck lawyers for the most part. You know those guys. You see them? Oh, you don't see them on TV? Those car wreck lawyers? Oh, okay. You don't watch much TV, do you? So,
We have a question right here.
yes,
No, right here.
yes.
So there's no legal form, whether S Corp, LLC, or that protects your personal, like your personal home, your personal assets?
Home is different now. Take my homestead class. Home is different. But my short answer, and this is my opinion, based on this case, the answer is there is no sort of business form for a real estate agent or broker to personally protect themselves. But again, I hesitate to say broker. I said before, I just said, remember, the brokerage can be sued. I didn't say that if your agent does something wrong, I said the agent can be sued based on this case personally. But there's no case I've ever seen that the broker can be sued personally, just the brokerage. So understand the distinction here, right? Not with a broker personally. But to answer your question, in my view, and this is my view, you could talk to some lawyers who have a different view, that you're not going to be protected from that. Okay, we lawyers are personally liable for everything.
Everything.
We're personally liable for everything we do, and the courts are basically saying the same about you folks. We absolutely can be sued personally. Absolutely.
What about writing title insurance?
Right.
You sign that same agreement that,
Yeah.
every underwriter asks us to sign to be personally responsible in case something goes wrong.
Absolutely. So there's a title claim or something, the underwriter can go after us personally.
Personally.
And sometimes they do. So yeah, these are all the things, and that's just where the law is basically going, folks, is more and more personal liability out there. So I'm just kind of pointing out where I'm seeing it. This is my view based on, and our view, I think your view too, based on this case. But again, that doesn't mean you can't argue otherwise. That doesn't mean you can't, I've seen judges get it wrong many times. But the law is what? Whatever the judge says it is.
On that comment, the broker cannot be sued. What about if the corporation is an S corp? So the brokerage office is an S corp.
Right?
Can the broker be personally sued?
No. In my view, no. In this Goichman case, no. Just the brokerage. And it doesn't matter if it's an S corp, C corp, or LLC. Those are really just tax distinctions.
Exactly.
Really the protection and lack of protection is about the same for a corporation or an LLC. A little different. All right.
Question over here.
I was just thinking that, just noticed that as a broker of a brokerage, the broker cannot be an entity of any sort. I had to drop the PA from my name in order to be the managing broker for the brokerage.
That makes sense.
It's just an interesting distinction.
Yeah, it is.
Because prior to that, they made me drop it, and I was like, oh, wait a minute, does that open me up to anything? And when I looked in it, I was like, no, it's just the same as it's always been.
Yeah. Moving on here, I just want, just a couple of hot topics here. You'd be surprised how recently I'm getting calls from experienced agents who what? They terminate their employment. Good, productive, experienced agents terminate their employment, they quit, and they get into fights with their broker about commissions. And all I can really say, folks, is you should really be really clear with your agents how that works. I'm pointing out right here the standard independent contractor agreement that's with Florida Realtors. And basically, if you look at this, page 7 and 8, you don't have to use this form. There's lots of different forms. This is one form. But it talks about compensation, page 8, paragraph 3C. It talks about commissions and percentages, that's fine. But look at page 8. The very second to last paragraph, paragraph 3.6, compensation after termination. That's where I'm seeing fights. After termination of this agreement, broker will pay associate any amount earned before termination, less amounts owed to broker, and amounts broker must pay another licensee to complete pending transactions for which associate was responsible before termination. So it appears to give you a great deal of latitude, doesn't it, to determine how much they're entitled to. I would add words to the effect of, that is at the broker's absolute and sole discretion. You don't want the agent arguing, well, wait a minute, any amount earned before termination, I want a judge to say, I earned more than you're saying I earned, or for there to be a fight. So if you're going to use this form and or verbiage like this, I would add verbiage that says the amount that they're entitled to is absolutely and solely at the broker's discretion. That way, it's much more hard for them to fight, much more difficult for them to fight you on how much they're entitled to or not.
So how do you suggest that they do that, to write on that form and make that addition onto that form?
Yeah.
Should they have their own addendum to that form?
Probably.
Their brokerage, and maybe they should just create that as a policy for their agents?
That's right. I probably would do that. However, you don't have to use this form. How many of you use this form for your agents? Some of you do and some of you don't. So you have your own form. What I'm getting at is, because I'm seeing fights there recently with good experienced agents, I would just make it, and they just had fights over, this is what I believe I earned. And I left because you're a bad broker, in both cases they said, and I'm leaving and this is what I think I'm earned. Then the broker says no. And now you have a fight. Now neither of those turned into litigation, but they were ugly. And both sides had to pay lawyers. If you put in there broker's absolute and sole discretion, that's a lot tougher for an agent to fight. And if I had a group of agents, I'd be arguing the other way. I would say you don't want the broker to have absolute and sole discretion, quite frankly. We lawyers are good for being able to, we're taught to argue both sides.
Patrick's got a question.
Page 9 has the additional terms, you could probably just put it on.
Yeah,
the
right.
list and use the same form.
Right.
And make sure it's included in every one.
Absolutely.
You just need to make it really clear. And that's the thing, I mean, everything's, hunky-dory and great when you're bringing them on, we're all friends, but, anybody who's had a business dispute, it can turn really ugly and hurt feelings and all of that, and I'm gonna badmouth you and all this. Let me say one other thing here on page 9. Paragraph 7, dispute resolution. What do you think about arbitration on these sorts of agreements, Annette?
So arbitration or binding arbitration?
Binding arbitration, which is what this
Let's
is.
explain what binding arbitration is and the distinction versus non-binding arbitration.
So, binding arbitration, which is what this is, and if you can check the box, is what I'm getting at paragraph 7. There's a box if you want to do. Both of these require mediation. This requires mediation, sit in a room, try to get it resolved, and often they do get resolved in mediation. I'm a big believer in mediation. You split the mediator's fee, okay? But arbitration is very different. It's a private trial. And it's sold out there to America as saying, well, a quicker, easier way to resolve disputes. But at the end of the day, guess what? It's also can be much more costly. Because instead of the county or the state paying for the judge, as they do in a regular lawsuit, and the judge's assistant, and the courtroom, and all of that, the parties pay for that. And it's kind of like the difference between public school and private school, right? One is sold as better than the other, but one is free, or almost free. So here's where I come down, and you may have a different view, and others may have a different view. But I've actually evolved my belief on arbitration. So arbitration, let me ask, before I say anything else, have you ever read a credit card agreement that you signed? Right? Have you ever bothered to read it? I guarantee you all of them, 100% say any disputes are arbitrated. Now, our credit card companies, do they have a reputation as being consumer friendly in this country? No. I'm just saying reputation. I didn't make an allegation. I'm asking a question, and I heard some no's. What I'm saying is this. Because of the cost of arbitration, it tends to what? Discourage litigation. And you can't appeal with arbitration. And you can't have class action lawsuits with arbitration. This is a big fight nationally. The United States Supreme Court has consistently upheld arbitration agreements, which absolutely plaintiffs' lawyers hate because they can't do class actions, they can't appeal. The biggest one is class actions. The Ninth Circuit, federal courts, right below the United States Supreme Court, including that liberal state of California, ever heard of that state? They hate the Supreme Court on this issue because they think that you should be able, that arbitration provisions should be invalidated at a court's discretion. And the United States Supreme Court has repeatedly said, Ninth Circuit, you're wrong. You may disagree with us, but we are going to say that across America, the law of the land, if parties agree to arbitrate, it's enforceable. The Ninth Circuit disagrees. The United States Supreme Court says they're enforceable. What I'm getting at is this. I do believe arbitration provisions tend to discourage litigation due to the cost. So what I'm telling you is that whoever, this is just my view, and you have a different view, but whoever is the one that's more likely to be sued should be the one who wants the arbitration provision. If you are more likely to be the one who is suing, I think you want to take an arbitration provision out. So just to tell you I put myself where my mouth is, you can believe my engagement documents with my clients contain arbitration provisions. It's not unethical. The Florida Bar allows it. It's in the Florida Bar rules that we can put in there that we have an arbitration provision. In fact, a very large personal injury firm, a case just came down, they had an arbitration provision in their agreements, a large personal injury firm everybody's heard of, and it wasn't exactly the wording that the Florida bar requires, the court nevertheless upheld the arbitration provision. That case came out recently. So what I'm getting at is many attorneys have this, and sometimes you almost got to say, good enough for the lawyer is good enough for me. Now you may disagree with that, but I'm just telling you. So I've evolved in that. I don't know where you come down on that.
I agree with you.
Yeah. So I'm just saying, whoever is the more, quite candidly, I don't sue clients just generally. I just don't think that's good practice, whatever. So quite frankly, though I haven't been, I'm more likely to be sued than to sue a client. So that's quite frankly, that's why it's in my agreement. So you as the broker, if you think you're more likely to be sued than sue, then I'm going to recommend that you check that box, because it's really a barrier. It just is. Because of the cost. Because of the cost. It's quite simple. It's about money.
All right. Before
Go ahead.
we go on, let's talk about agents who choose to leave your brokerage and go to another brokerage. And what's the process and what is the best practice for what you as the broker should do? Don't let your agents leave on just a handshake or a verbal agreement as to what's going to happen with the commission for that listing. I don't know what you see, but I see, and there's a lot of fast talking that comes, oh no, wait, I was at that brokerage, but now I'm at this one, so we're going to pay all the commission through this brokerage. We're not paying anything except for what's in the listing agreement and what is stated in the MLS, period, and discussion. If you, agent, don't have it in writing, it's not happening. You agree?
Absolutely. It's got to come from the broker.
It's got to come from the broker.
And I've seen fights there too on closings.
Bad fights.
Yeah. Where
that
they
could
say,
be avoided.
Yeah, that where pay this to me and pay that to me, and it's got to come from the broker. Who owns the listings, folks? The broker owns the listings.
It's got to come from the broker, and my broker said it's okay. Really? Show me, you're laughing, Carolyn, right? Show me that agreement. Show me where it's okay. Otherwise, as a closing agent, we are bound to close, or we are bound to pay whatever brokerage had the listing.
That's right. Whoever had the listing. So.
And the new broker doesn't have any say, do they?
No, they don't have any say. They don't have any say. That absolutely not. Anything else on that? That's a good point.
Well, there has to be a paper trail.
But they don't want a paper trail. That's the point.
Who they? The
Agents.
agent. Because it doesn't, I understand what you're saying. But I can't imagine that the specifics aren't in the books. Whether it's a listing, how much your commission should be on that listing, so there shouldn't be any problem or dysfunction as to how much I owe you.
I just had one about 3 weeks ago, and it got so bad that the agent, was trying, and well, I was at this brokerage, and now I'm at this brokerage, so you know what, it'll just be easier if you just give me the one check for the 2 properties to the new brokerage. Not doing it. We're not doing it.
And keep in mind, too, go ahead.
Wait, so let me call your former broker and let me have that discussion. Oh, no. What do you think happened? Who do you think got paid? Former broker on both properties.
But a lot of times agents will try to bully the title company because the title company relies on them for referrals. And they will literally basically try to say to the title company or title attorney, we both write title, will basically say, hey, look, without saying it, they'll basically imply, if you don't do what I say, I'm not sending you any future business. I've seen that happen.
They don't want that business.
No, that's the
You don't
whole
want their
point.
business anyway.
You don't want.
No,
Yeah.
exactly. But I've seen that happen where they try to bully them based upon the referral power that they have.
You want the business for the agents and the brokerages who are ethical, who want you to perform in that same manner.
Exactly.
Yeah, so this is great timing. We actually are in the process of redoing our agreement with the agents. And in providing leads to the agents, there's over 16,000 leads in there. And our agreement says they shouldn't take them with them if they leave. But if they do, the remuneration should be exactly as if they were with us. And we just run into all kinds of issues and problems with that. So nothing was listed, nothing was written as a contract. They took my paid leads and left. And then within 30 days, whatever, looking in LEPA, you can see the name that's in my dashboard. They stole the leads and took it with them. Thought I had an ironclad agreement. And working with an attorney right now, just trying to figure out, I mean, we are out. The 50% due to us is over $300,000 right now.
So now we've narrowed the scope down to not just the current listings, but now she's encompassed leads in that. What's your opinion on that? I mean, is there a time period where the leads are only, so relevant and ripe, or how does?
It says indefinitely.
Right. You've got to be really specific in your employment agreement, spelling out very carefully what they're worth and what happens very specifically. Don't just say in your agreement, well, we have all rights and remedies according to Florida law. No, you need to specifically say, if this happens, this is our remedy. And in your situation, you might not want an arbitration provision.
Right.
Because it sounds like you may have to go after an agent.
Well, we've all received an attorney letter, which produced nothing. So the next step, is going to be quite expensive. And it also says in there, they're to pay the legal fees.
The loser pays the winner's attorney's fees, yeah. That's what many of these documents say.
They're all losers.
Are the lawyers losers in that?
No.
They're going to win a lot.
Quick question. If an agent leaves on good terms, and we are in agreement with what that compensation should be for pending transactions, I'm under the understanding that I can't even write a check to that agent. I would assume that I have to pay that agent's new broker, and then that broker would disperse the funds down to that agent. But I think it happens the other way. I've experienced it firsthand, where my old broker paid me directly, and I didn't say anything about it. I was happy to get the check as we had agreed. But being the devil's advocate, I can see how they were paying a sales associate when I really wasn't their agent anymore.
Well, that's something else maybe you ought to spell out in your employment agreement. Said payment will be directly to agent, not to the broker.
And what do you think of that? I mean, do you think that that's the proper way, that the broker should actually disperse the funds to the new brokerage and then have...
I do. That sounds like the better course of action, but remember... That sounds like the better course of action, but we're seeing brokers cut check, we're seeing brokers tell title companies all the time to cut checks directly to agents. I mean, that's the standard these days.
The disbursement authorization.
Yeah, right, which blows me away that even goes on, because you used to not be able to do that at all. To me, that's just because the broker doesn't want to fool with the accounting.
But in his scenario, let's think about, so the new broker, why should they have to be burdened with the payment on a listing
Because
just closed?
Because their agent's receiving compensation for a real estate transaction, and they're not
They
allowed
have to
to do
report
it.
it. But the agreement was important, the person was transferred.
But not under the new brokerage, under the old brokerage.
Right.
Yeah, okay.
What do you think?
I don't know.
I can't imagine the new broker would want to be burdened with something that, what kind of benefit are they getting from it?
I would consult with the new broker. If you don't have it clearly spelled out in your employment agreement, I would consult with the new broker to find out how they want that to happen. And if you don't hear from the new broker, if the new broker won't respond to you,
Just pay him.
right.
But what kind
I'm not an attorney, but my thought is, compensation flows through the broker,
Right.
and really what's happening is who's then responsible for the 1099
Right.
reporting. So I agree with Annette that if I were the new broker, I'd say, well, why do I want to add your accounting burden onto my plate?
And if I take the position of the new broker, why do I want any relationship to that former listing, that former sale of which my office was not a part of? Why do I want any liability for
Because
that?
but you're the current broker. Shouldn't
As
all the
long as
money?
you're actively licensed, that's the strict
Yeah,
business
I'm-
of paying a commission to a
I'm in that
licensed
situation
person.
where I'm taking a portion of the commission to cover liability insurance. Because if I'm the new broker, in that transaction, it's not complete. So I'm responsible for the time that they become employed to the closing.
I do the same thing, I
So-
take
Who
5%.
cares about accounting? That's easy, but liability is more important.
So then do you think that that's something that should be in the agreement when the
I think-
agent leaves?
Yes, it should be part of your employment agreement. So right there, when it says, you know, the broker gets to determine how much you get, I think you need to say, that money will be paid either directly to the agent or to the new broker, so there's no confusion. I mean, my general bias, and maybe it's an anachronism, is, shouldn't all money go through the current broker? The new current broker? I see some disagreement on that, so it's obviously a gray area here. But my general view is, whoever the new broker is where the money's supposed to flow. That's kind of yesteryear, maybe.
If let's say, I'm the new broker, I would not take the payment. I'm not taking the liability, and
Fair enough.
I have nothing to do with the contract that was signed by the old broker and the agent.
So we've got different
Views.
Because we've got this one over here
Right.
that's, you know, already taking into account, I'm taking 5% for a
But if you're the new broker and you say, I'm not taking the money, and you don't have to, real simple, you don't have to take any check you don't want to take, right? In this world. So if you don't want to take it, then it has to go obviously directly to the new agent. It has to.
But aren't I still responsible for the agent's action under my?
Exactly.
Perhaps.
So if you're
Yeah.
gonna file a lawsuit, you suing the old broker and the new broker in that
Probably.
scenario?
Yep.
Probably.
We got
So you do,
one
I
right
was gonna
here.
say, you do have liability whether you take the money or not. As soon as you sign the contract agreement with the agent, whether you want to touch that old commission or not, from that day till the day of closing, that agent may do something unethical that you're responsible for.
Just ask Rose Realty West, the case I just went over, right?
Yeah, like how long does that actually go for? Because like, you know, for instance, in new construction, I've been in new construction where it takes 10 months to build a home. If you have an agent that goes in and has 10 months to build a home and they go to a different broker, that 10 months is flowing for the old broker or the new broker. That's a long time to wait, you know. Usually resale closes in a month, you know.
If there's something going on, there's probably going to be a lawyer that's just going to throw the spaghetti against the wall and sue everybody. And let's see how it plays out. That's generally what attorneys do. Try to get a pound of flesh from each person. And I'm using that, you know, that's an old Shakespeare term, right? A pound of flesh. I'm just saying, that's just the way the game is played, like it or not.
What I still don't understand, whether it be in the courts or whether it be between two different brokerages, if I have an agent who has signed an agreement and there are dates and times and everything filled out and there's no dispute about that, and a sale took place while that agent was my agent, and the dates and the times and everything is clear, how does the new brokerage even get involved in any of that?
You just heard his answer. He's gonna sue the old brokerage and the new brokerage.
And they're going to allege that because that was your broker, this was your broker, at the time that you committed the negligence or malpractice, you're vicariously liable.
Yeah, because the
No, I mean
old
with
broker's
the
actually
commission
getting
check.
Oh, the commission check, we're not, you know, it's a little different. But I'm just talking about liability there. Commission check, obviously, this is a gray area here. We're getting different views on it, and quite frankly, it's going to come down to whatever the employment agreement says, and if it's silent, whatever the brokers agree to. But I agree. I think the first thing you do is the old broker contacts the new broker and ask them, how do you want to handle it? If they hate each other and don't want to talk to each other because they're competitors, then you figure out some other way. I've seen that too.
I'm going to revisit an old agreement that I
Yeah.
signed from a former employer who I remember was very distinct in saying that anything that's pending here when you leave will be closed here.
Mhm.
We will close it. We will not be assigning any contracts.
Oh, and that's what this says too.
Contracts to any other brokers to deal with.
This says that too. This basically says that too. That any deal, if you leave while a deal, it basically says, if you leave while a deal is pending,
Right.
I don't have to transfer anything.
Exactly.
Now, the problem is what? You've seen this happen. They get with who? Their seller. And say, let's, go and terminate this with my old broker. Well, guess what? Unless the brokerage agreement says you can terminate at will, which this standard form doesn't, this standard form has what? The standard listing form has what? A conditional termination that the broker doesn't have to agree to. And that's the other thing you need to make real clear, in your listing agreements. You don't have to use this standard form. Let's segue into this is the listing agreement form. What I wanted to point out yet again is, take a look at page 12, paragraph 12. There too is an arbitration provision. Whether or not you want to check that box, I don't know, because if you want to sue a seller, you're going to have to arbitrate it. What's good for the goose is good for the gander, and that may end up biting you, possibly. Depends on your viewpoint. You may or may not want to check that. You know what I mean? What if you want to sue a seller for an unpaid commission? You're going to have to arbitrate it, which you may or may not want to do. The other issue that I wanted to point out real quickly on this, and I think, by the way, this listing agreement, just like the FAR bar, it's too long, it's too confusing, and quite frankly, I think it should be condensed. But what I'm getting at is, has this happened to anybody? I want to point out something I've seen happen on this thing, and that is page 12, line 122, the protection period. Who here's been jacked by this? What does it say? Do you have a protection period? So if what? If the contract, the listing agreement expires, and then line 122, if within blank days after termination, seller transfers or contracts to transfer the property or any interest in the property to any prospects to whom seller, broker, any real estate licensee communicated during the property with regard to the property before the termination date. Here's the kicker. However, oh, I love that word. You know something bad's about to happen. No fee will be due to broker if the property is relisted after termination date and sold through another broker. Who here's been jacked by that? You have. Almost. And some of you have been jacked by it, but you just didn't know.
That's the oh my goodness that we just got.
Yeah, you just didn't know. In other words, I've seen this where literally people have come to me and said, guess what? Let's play a game. Jerk over the agent and the brokerage. And then they find a friend with a broker license, right, during the protection period, who will charge him something small or whatever, one of these cut rate brokerages. They'll relist it, sell it to another prospect, and save the fat commission. I had somebody who said, over in Sanibel, we're going back a few years, over in Sanibel, he says, I lost a $40,000 commission because that's exactly what happened to me. So I understand why that's in there, to avoid double commissions, but I think you need to consider crossing those lines out. Okay? Quite frankly, because that voids the protection period if they get clever. They can relist it with the intent of not paying you a commission with a cut rate broker.
Can I share just one more
Go ahead.
story on that? I had a very clever seller. They relisted with another broker, but named a buyer as an exclusion on that listing agreement. And then that buyer's broker closed the deal.
Mm-hmm.
We took them to mediation and we won.
Yeah,
We
because that was an exclusion.
We settled for half because it was prima facie evidence that they were doing that to circumvent the listing agreement.
But you're saying that was, yeah, that's right. That's right.
They went and listed it with another broker just for the sole purpose of eliminating this with their buyer who was introduced to them through when we had the listing agreement.
But you said that was an exclusion. That buyer was listed as an exclusion.
That they excluded that buyer from their new listing agreement.
Oh, from the new listing.
From the new listing agreement, and then closed it.
Well, you're lucky you got half, because I'm not sure a court would have given you that. Because it says what it says. Yeah. We see all the time. We read court opinions all the time, and all the time they'll say, well, the plain language says this.
Yeah.
You're lucky you got half.
However, line from the listing agreement.
I think if I were a broker, you do what you want.
Right.
I would cross those lines out. Don't negotiate against yourself.
Yeah.
If they want to add those lines, let them add those lines. You know, it isn't fair to pay 2 commissions. I understand that. Come talk to me if you think you're going to pay 2 commissions. right? What's much more likely to happen is than them paying 2 commissions is them trying to jack you. So I've seen that. Okay, moving on here. Page 14, I didn't even know this form existed. Notice of multiple offers to buyers. I didn't know, it came out in 18. You've been using it. You know more about contracts than I do, because I didn't even know about this form. Maybe I shouldn't be teaching contracts. Page 14, this is a Florida Realtor's form. I think it's pretty cool. Where you got multiple offers, you can fill this out, and you can basically say, submit your highest and best. And it has all these disclaimers. Not a bad form to say highest and best. And frankly, I think highest and best is the better way to do it versus, what do you think, Annette, of this page 15, this new escalation addendum? I don't like it either. This escalation agreement, it literally says, part of the problem is you've got to have a competing offer that's bona fide and unexpired. And I'll tell you what, I'd love to play poker with a buyer that signs one of these escalation addenda because they're telling me how high they'll go.
Right.
I mean, that's an invitation.
Well, Nat, I just saw one, just to let you know
Yeah.
how slick folks are becoming. There was an escalation addendum.
Yeah.
But there was a caveat that the property must appraise at a
Oh.
certain amount. So
Oh.
it was basically a teaser. It was, get excited about the escalation.
Yeah.
Don't read the rest of the contract, and you're gonna see that property returning to the market, as a lot of these are, once folks start doing.
You mean they included page 24, the appraisal contingency? There you go. Yeah, so folks, I think this whole escalation addendum, I smell problems, I smell wasted time, I smell frustration, a bona fide, unexpired, basically this is go shop another offer and I'll beat it.
Yeah.
Well, how do you know it's a real offer? Because it says you get to obliterate the competing buyer's information. You can't verify it's real. Plus, it doesn't say anything about terms. It just talks about price. Most sellers will accept a lower price for a cash deal. So you could get a higher price that isn't cash or has terms like, yeah, we'll close in 2 years. You know?
Don't you think that?
$100 deposit.
Don't you think that's going to evaporate once this market transitions?
Oh, absolutely. It won't evaporate, it just won't be used. Right?
It'll be pointless.
It'll be pointless.
Go back page. I don't know how relevant it is to mention, if you were to use this notice of multiple offers to buyers, when talking to your agents, because I do teach the contract series, and I get agents that are brand new, and I get agents that have been doing it for 20 plus years, there's confusion with regard to the backup contract rider. And that backup contract rider very clearly sets forth that as soon as the first contract is terminated, the next in sequence, in consecutive order, contract is going to move into what? What's that verbiage? First position. So if you're ever talking about, make sure the distinction is made, this is a notice of multiple offer to buyers, not contract. Because agents still think that if they're in a backup contract situation, if they have 4, they think that as soon as original contract is done, they can renegotiate between 1, 2, 3, and 4 for the highest and best. Can you do that?
No.
Absolutely not.
And it goes on to say in all these disclaimers down here, they are just offers. We don't have to respond to your offer, right? What's the common misunderstanding? Well, I have a full price offer, you have to accept it. No, I don't. I don't have to accept any offer I don't want to, unless I'm a bigot and I say I don't want that offer because the people seem like they're from Neptune. Obviously, you can't do that, okay? And if a seller says, no, these folks, that name looks like a Neptunian name, no, obviously, no, that's discrimination. You cannot participate in that. But short of that, the seller doesn't have to respond to any offer at all. It says that here, and that's true, full price or not. Now there is, you teach Code of Ethics. Code of Ethics does say there's something new in the Code of Ethics that says you have to respond, right? What does it say? There's a new Code of Ethics that says if somebody's asking you what happened to my offer? You do have to respond.
And that's the mistake is that most people make is ask.
Yeah.
Has my offer been received and presented? Then
And
if
then-
somebody lies to you, we got a whole other problem.
Right. They have to
You're
respond.
getting bent out of shape, but I'm saying, well, did you ask?
Yeah.
Don't just presume.
Right. So that there is a relatively new part of the code of ethics.
And
You
don't
ju-
ask using hate language, just saying.
Yeah, just,
That's another thing.
it is a violation of the code of ethics if they don't respond, the listing agent doesn't respond, then you can bring them up on code, or remind them of the code, and take a look at the code of ethics on
But
that.
luckily, the new contract is not, this whole nonsense if you have to check the box that you're rejecting is not relevant. That is not a requirement. So many people think they had to fill out the last page where it says counter or reject. That's not necessary.
So a comment and a concern about highest and best. Over the years of doing this, nearly 20, I've seen a lot of scenarios where you track the deal and you didn't get it, but the office that has the listing gets it. So something I put in practice a long time ago is, and I don't know that a lot of people do this, is that I call highest and best with my agents first if they're involved in a transaction of our listing. Once we get the highest and best back from our agents, then we push it out to the general other offices. So that we have a time, date stamp return of that highest and best with our agents. We're never caught saying, hey, this agent brought it in afterwards. So I don't know if anybody's had this scenario or situation happen, but I've seen it more times than not where the agent's brokerage office that listed it is getting the deal.
Well, to be devil's advocate, how are you preventing that when it's known that you're letting your office cherry pick before the rest?
Not cherry
of the-
pick, no, I'm calling highest and best. The deadline for my agents are before the other agents, so I'm getting their highest and best in my office, in my possession.
I understand what you're saying,
Prior
you're looking at that
to-
first.
But isn't that making that a pocket listing?
No, he's talking about the opposite, so.
Only the highest and best. So I have a highest and best deadline that I'm gonna get it this day. Well, I'm gonna get it back to my current agents first, then I receive the other highest and best behind that. Therefore, I show proof, I have proof that my highest and best, my agents did not trump anything else.
Okay.
It was
Let's take one more question on this, then we gotta move on.
We got
Okay, go
two in the
ahead.
back.
Two in the back, then three more questions, then we'll move on.
It's not a normal offer, it's back to the escalation.
Yeah.
Is there any legal or ethical issue with putting a disclaimer in the listing, saying the agent remarks that you won't accept any kind of escalation addendums?
No, you can say that. You can say that, absolutely. If your seller instructs you in writing that they will not accept an escalation addendum, you can do that. Remember, you don't have to respond to anything that is not, in common misperception that agents have, that you have to respond to any and all offer. No. You only have to respond to offers that meet your seller's parameters, as long as they're not discriminatory. So you can put that on there, but be sure you get in your listing agreement that you have your seller instructing you. We will not respond, I'm instructing my broker not to respond to any offers with an escalation addendum. I don't really see that addendum being a successful addendum. It's too problematic.
Now, can I throw something out there since this is a broker room? One thing I'm seeing with just true statistic, the number of folks testing for the state real estate exam is up 82% from last year. So we have a lot of folks that, let's just put it mildly, do not know what they're doing. Be very, very careful. I hear a lot of language out there. The seller is reviewing an offer that is better than yours. The agent cannot make that determination unless they either A, have power of attorney, or B, were directed in writing from the seller with what they'll look at and not look at. And I'm just seeing huge overreach by agents making decisions about what they think is best versus coming from the words of the customer. So just want to throw that out there. It's the Wild West right now, so.
And I hate markets like this. I really
know,
do.
I
It's just, I've seen this before in 04, 05, and 06, and there's all kinds of games going on, anger, frustration, greed, it just gets really frustrating.
And the customer bears the brunt.
Of
They're
course.
the ones that's ultimately hurt, which then makes the regulators turn their heads back in this direction.
That's right.
And say, what are you all doing wrong?
That's
And
right.
That's not best in interest in anybody's business.
Well put.
It's have the
Somebody
government
back
decide
that
who
up.
you're right.
Yeah, go ahead. In the back?
Yeah, who in the back was raising their hand? We had two in the back. No, they decided not to. Okay.
Did you have one?
On the highest and best, I've been on the end of someone accusing me of something unethical in the highest and best situation because I closed it. I had the buyer and the seller, double dip the deal.
Yeah.
And every single one of my listings, I have a variable rate commission.
Really?
My seller enjoys a benefit if I close the deal. And I have to disclose that in the MLS, and I do. And never once have I had a buyer's agent ask me, what is the advantage? They've never asked me, and if they had asked me, I would have to tell them exactly how much money my seller is going to save by choosing my buyer over their buyer. So when they come to me afterwards and say, hey, you closed that deal for a few pennies less than the one we had offered, I don't have anything to say because they never asked me what the terms were of that variable rate. And they are supposed to. The buyer's agent, it says somewhere in the, I think in the MLS rules, that the buyer's agent is supposed to find out from a listing agent or broker what sort of disadvantage does my buyer have in this situation compared to the listing broker's buyers.
Well, at the end of the day, your seller netted more money, didn't they? Because they paid less of a commission by having you on both sides.
Or maybe they didn't have to deal with a financing
Right.
headache.
Could be
or
anything.
Whatever it was.
It isn't just price, there's terms too, folks.
But there's
But it
always,
goes back to, folks don't know what it means. I'll just put it right out there. You can put variable rate on the
they don't know
MLS
what it
and
means.
people don't
They
even know what
really
it means.
don't.
Right. Or they think that all commissions by law must be split 50-50. I've run into agents like that, outraged that there was a different commission, okay, for the buyer's agent versus the seller's agent and/or that it was variable rate. They just need to be educated. They just don't understand that you can have variable rate commissions and different commissions for buyer's agent versus seller. It's all whatever the contract says between the listing broker and the seller. It's a contract. It's called a listing agreement. And it's a we just saw it, it's a too long, multiple page document. And just like everything, every word matters. There's too many words, but even the words that are there do matter.
And it's more than fair because to suggest otherwise would be an antitrust violation, which puts you in a bigger problem. So
Exactly.
I've got a whole list of new classes for you two.
Let's just wrap it up here and then we'll take some questions. I just wanted to point something else that I'm seeing. I'm just throwing this out there, FYI, page 19. This is the condo addendum. I've had experienced agents mess this up more than once that I've seen. Page 19, the non-developer disclosure. You know what I'm talking about. You check the box 5B. This is the laundry list of documents that the seller must produce at the seller's expense to the buyer. Most of these documents are straightforward. Here's where I've seen mess-ups, and don't fall into this trap. I saw this recently from an allegedly experienced high-end agent. It says here, this is, you know the deal. On a condo only, you can cancel the contract within 3 days of the buyer's receipt of the last of these documents. Here's the one where I'm seeing mistakes. The most recent year-end financial information. Too many management companies and/or presidents of associations will give you a budget. It doesn't say budget. It says most recent year-end financial information. I've seen buyers who want out of deals who go see lawyers who know what they're doing, and they say, where's the most recent year-end financial? I didn't give it to you. Why? Because I didn't read this and I thought a budget satisfied that requirement. It doesn't. Don't let the buyer have a cheap way of getting out of the deal by giving them the wrong documents. Because remember, that 3-day clock starts on the buyer's receipt of the last of those. If you didn't give it in the first place, they can cancel anytime prior to closing. Something to throw out. Have you seen that?
Yeah.
Yeah. So anyway, and then,
But what I see is the agents don't understand, which.
they didn't read it.
But no, not that they didn't read it, they don't understand because it hasn't been explained to them. So you have to have that dialogue to make sure that your agents really understand what's happening.
Right. Page 20, make sure if you represent a buyer, because we lawyers will argue both sides. They teach us that. Page 6, make sure if you represent a buyer, you check the box requests those documents. Don't leave it blank. To make sure you're requesting those documents and that you can cancel within 3 days if you receive the last of them. And then just, we'll round it out. We don't need to go over it right now, but I included a couple of PowerPoints on what I've talked about for the new FAR bar contract changes. You're teaching something coming up on that, aren't you?
I'm teaching it again on Friday.
Friday.
Friday afternoon. But wait a second, Angela, are we full?
We are full.
So be careful.
Okay.
We're full and we're gonna do it again, or that's it, after Friday?
Ned has a class coming up December 3rd, Friday, December 3rd.
Let me look. Friday, just to confirm, we just talked about this, didn't we? We did. So the one on Friday, but sometimes there's no shows. So if you want to come Friday with Annette, right? If there's no shows, you'll let them in?
Yes.
Okay. And there's always some no shows. So if you want to come on Friday for Annette's class, show up, because there might be some no shows. And if you're nice to Angela, she might lift the tent and let you in. And then Friday, December 3rd, I'm teaching it right here. It's not full yet. We just set it up. Lastly, I just wanted to go over, and then anything you want to say, Annette. When it comes down to personal property, whenever I teach the contract class, and so I'm sure Annette too, I always spend a lot of time on personal property. Because that's where there's lots of disagreement, misunderstandings, and fights. All I'm doing with this, again, this is kind of a potpourri type of class, page 23. This is the first page of the Naples contract. Why am I giving you the first page of the Naples contract? The reason I'm giving it to you is, you can see for personal property, it's much more comprehensive than the FAR bar. In other words, the default items are much more comprehensive. So I merely wanted to bring it to your attention. For example, look at all the stuff. Line 4, they talk about beverage coolers, shelving, home automation, audio-visual, home entertainment. These are all default items included. FAR bar addresses none of this. Home sound systems, operational components and software, central vacuum system, including the doggone hoses, and water softener. None of this is in the FAR bar. I'm really just pointing these out as areas where you might want to add for the FAR bar, or stuff for you to think about. Home generator. Now some of these are clearly fixtures, and why they're including them here I'm not sure. I guess because there could be a dispute. Surveillance system, including cameras. FAR bar addresses none of that. Television brackets, the new one includes that.
And wall mounting.
And wall mountings, but this clearly excludes the televisions. FAR bar does not mention anything about televisions. Pool equipment, unmentioned in FAR bar. Keep reading. Washer and dryer, line 11, unmentioned in FAR bar. That's the biggest glaring missing thing in the FAR bar, is no washer
Still,
dryer.
after how many revisions?
Still, after how many revisions? What else here?
You got microwave in there?
Microwave is in here. Pool, line 13. Pool or solar cover, unmentioned in FAR bar. Child safety fence, unmentioned in FAR bar. Automated pool cleaning equipment, unmentioned. I'm just throwing this out there. This is a class, we're talking about all kinds of stuff, and I just wanted to point out one of the biggest things you might want to think about is, do you want to manually add that stuff into the FAR bar contract? And then there's the appraisal contingency, which is more relevant now, I think, because the new FAR bar, they rewrote the financing section, and now the financing, and you'll learn about it in her class on Friday, now the financing section talks about where you have to have what? The appraisal or other opinion of value must be done up front during the loan approval period. You can't later cancel. So that appraisal addendum is going to be more important, I think.
I think we
Go
should go
ahead.
into this.
You can.
All right.
It's your idea,
So-
and it's a good one.
So with the new revision for the FAR contract, paragraph 8 was a whole mess, and a lot of agents didn't understand. So working through it for the past 2 months, I think that it's simple enough to explain to your agents. It's really just 4 different definitions. And you can write these down, and then if you read in the actual form, you can actually get the definitions from the form. And then I think it simplifies the whole confusion and hesitation and stressfulness for especially the new agents. So the 4 definitions are, the first one is loan approval period. Loan approval period is what? The time period in which you have to get the approval of the loan. Very basic. Then what do we have? The next definition is what? Financing. Financing is the actual terms of the financing, the interest rate, the length of the loan, the type of loan. Third is going to be appraisal. What is the definition of appraisal these days, Ned?
It is either an appraisal from a licensed appraiser or some other alternative valuation. I guess that could mean a Zillow.
Or a desktop.
Yeah.
Right.
A broker's opinion. It just says alternative valuation at the lender's discretion.
If required by lender. And then the 4th definition is what? Loan approval. And loan approval is comprised of the definition of financing and appraisal and loan approval period. That's it. I don't see that it is any more complicated than that. So take those 4 words, go back and look at your form. Let us know if there's any questions, but I think it can be very much simplified to those 4 words.
And the main thing
It's a commitment. A loan
No.
approval.
So what happened in 2014 or 15, I don't remember the year, but they actually interchanged the word loan commitment with loan approval. Now, what do we know about that? Loan commit was somewhat defined. Now, loan approval is not even defined in our forms. But what do we know? What came with the commitment? Conditions, and then what? You have to get approval of the closing statement from the lender, and then you have to actually get that, what's that next C word? Clear to close, before you're closing. Is it any different today with the loan approval substitution? Ned, would you say yes or no?
What?
Never mind. It's not any different. It's not any different today. So all they did was substitute the word loan commitment to loan approval.
And they're not defined.
Loan approval is not defined until we get to this new portion under paragraph 8 for the new 2021 revisions where you actually get the definition of loan approval. But it's not echoing or mirroring at all the prior definition to loan commitment. What did they do when they did the change out? They put the word what? Reserved. They should have defined the word loan approval, but they didn't.
You know, the financing section, every iteration of the FAR, they rewrite it, they fix some problems and create others. The biggest change now, you've probably seen it, is what? No, you can still stay in the deal, even if you don't get loan approval within the loan approval period. That's a major change. All it says is you can either give loan approval, cancel, or what? Tell them that you're what? Satisfied with your ability to get loan approval.
So I didn't think we were going to go there today, but
No.
now you have to do 30 seconds or less of explaining to the brokers to discuss with your agents what that really means as far as liability for your agents. So if your agents are going to talk to their customers and their customers are going to say, I am satisfied.
What does that word mean?
Right. What does that really mean?
You deposit on the hook.
Worse than that.
You're gonna buy the house.
But if you're not going to get that loan approval that you were so satisfied about, then what? What does that look like on the other side of this?
Seller keeps escrow.
At least. At least. And I think it's really productive
And
to
then you're
discuss
saying-
with,
I'm sorry, you're saying that they can sue for damages too? If they don't
look
close?
at the default.
Is that, I'm
So
sorry.
hang on a second. So I think that as brokers, it's a good idea for you to discuss with your agents that they really need to get that explanation of what satisfied means in writing. And that discussion really needs to be in writing, because what does sending "I'm satisfied" notice mean to the buyer? So my opinion, I don't know, we didn't discuss this, my opinion is it means you get to stay, buyer, in the game so that the seller cannot what?
Cancel.
In what? 3 days.
Right. You need to be real careful. I agree totally. You need to be really, tell your agents, if they're going to play this game of being, or it's not,
It's a risky
not a
game.
Yeah, it's a
It's a
risky
risky
game
place to go.
of playing, okay, we can stay in the deal. You don't have loan approval, but let's tell them we're satisfied of your ability to get loan approval. You need to really, to avoid liability, you need to make sure you're involved in that email. Really. You need to make sure you're involved in that email, to make sure you read that email, to make sure you get it in writing from the buyer, that they understand what that means,
The consequences.
the consequences, and that they understand what it means, and don't come crying on my shoulder, the broker, the agent, if you don't get your loan approval. Folks, your buyer picked the lender. You didn't pick the lender. The buyer is responsible for the lender. Okay, they picked them. It's not your fault if they didn't get loan approval. And so, you know, it's really, I agree, it's a risky game to be saying, I'm satisfied with my ability to get loan approval, because what it says is, if you don't get loan approval, your deposit's at risk, or you could be sued for damages, and or if you do get loan approval, the only way to cancel it is what? If the property-related conditions of the loan approval are not met. That hasn't changed. That's it. No longer can you cancel if it, on the back end, if it didn't appraise.
Unless you have
Unless you
this.
include the appraisal addendum, right? So again, they've changed it. You need to understand it, read it, the financing section a bunch of times, because they always change it. Every iteration, that's the main section they've changed. You can tell the committee that puts together the FAR bar is in complete disagreement as to what it should say. That's why it's so long.
I think we have to take a question.
I had a title company in Miami switch from a conventional loan to an FHA without telling the seller.
A title company did that?
No, lender. The title company actually was the one who sent, I asked for information and what was going on, and the title company sent me the information. And I see in the information what they are asking for in reference to inspections, blah, blah, blah. So I called them up and I said to her, we are having a conventional loan, that's what the contract says. And she says, well, the buyer changed it, so we are just following up on the buyer.
Well, they have to sign an addendum, there's a FHA.
Yeah, I know they
addendum.
have to sign, they didn't. The title company, we were in the last leg already, and the title company just changed it. I mean, sure, the lender changed it, whatever they did, but nobody told the seller, which I represented, so I'm finding out through the documents from the title company that they changed the loan.
Yeah, so let
The fact that the sellers then said to me, let's just go ahead, we are almost at the end, let's just do it. But in all reality, in my opinion, I don't know what you want to call this, I think this is whatever.
Well, that's a good point. Somebody said, you know, we're always up here teaching contracts. You got to do this, you got to do this. You know, somebody said something to me that was the elephant in the room in a class a couple years ago. They said, I hear what you're saying, counselor, but let me tell you something. I've seen the messiest, sloppiest contracts on earth still close. And I thought, you know, you got a point.
I had the legal hotline tell me that.
Yeah, you got a point. I never really thought about that. We're always telling you what can go wrong, and yet that's really only if somebody either wants out of the deal or whatever. Sometimes a piece of garbage ends up closing. It's remarkable. I never really thought about that, but it's true. So, you know, so even if you have a piece of garbage contract, it still might close. Avoid it.
I actually had that happen. I had that happen as well, but I let the seller know as soon as we knew that that could not close as a conventional loan, and they had all the money in the world. The down payment was $80,000, the house was only $300, so they had all the money in the world. They just needed that FHA to get approved. And so we went through the process. The seller wasn't happy at first, but it all worked out. We closed, it was fine.
Yeah.
You know, the hardest thing about it is insurance right now, you know, if the house is older or whatever, to get that FHA, but it did work out. The other one, Ned, is like a buyer that says, okay, I'm paying cash, and then wants to flip to financing.
Well, that's addressed in the new form.
It's in that form, and it's in the farm contract that states, you know, if you're paying cash, but if you decide to finance, that is just on time. That
Well, have you seen the new form, though?
Oh, so
She doesn't know what the new paragraph
Oh,
8A is.
So the new paragraph 8A says, the old one said, but let me tell you something, I got a comment on this. So the old one said that buyer shall pay cash, if you want to check the box for cash, the old FAR bar said, said, buyer shall pay cash with no financing contingency, and then it went on to say, if buyer obtains a loan for any part of the purchase price, this isn't contingent upon that.
But what does that really mean, though?
Thank you.
That means that they are not reaping the benefits of paragraph 5A, which means the automatic, in the former version, 10-day, it's now 7-day, closing extension in the event the CFPB delivery requirements are not met. So you couldn't reap the benefits of that. You also could not reap the benefits under paragraph 8B for trying to cancel and get the deposit back because you wrote a cash offer. Now the committee said, we're going to make it really simple. This is cash. That's what paragraph 8A says.
Yes and no. Because what does it say now? That's what I'm getting at. I was teaching this at another the updates at another association. And what it said, and somebody brought up in the audience, it said, the box now says, this is a cash transaction with no contingency for financing, period. Then it ends. And I said, no more bogus cash deals. It's got to be cash. And somebody in the audience said, how do you know? It just says no financing contingency. Why can't I still get a loan?
Well,
It doesn't prohibit a loan. They had a point. Nowhere does it prohibit a loan secured by the property. And so I was out saying, oh, no more bogus cash deals. Maybe it is. So we were at a panel here before and we were saying, why don't you just say add in the addendum, and this is number one, demand what? Proof of funds before you go under contract if you have a cash deal, liquid funds. Secondly, I'm still arguing you should put in the contract this, I would add additional terms because that's still, somebody did, I was saying, well, now you can't get a loan. But it doesn't specifically prohibit
I can't get there.
a loan.
I can't get there on that. It never said you could never get a loan.
It doesn't say you can't get a loan.
Yeah, because you have buyers that have the liquid money.
Yeah.
And
They want low interest
They want
rates.
the $2, the 2%
Right.
interest rate that they're giving out. So, instead of paying 2 closing costs, they decide to go ahead and
Right.
do that.
But anyway, what I'm recommending still is, in an abundance of caution, put in the additional terms, this is a cash transaction, buyer shall not obtain a loan for any part of the purchase price. That's what I would do if I had a listing and I was cash deal. I would literally put in the additional terms, buyer shall not obtain a loan for any part of the purchase price. And what we're talking about, though, someone asked me a question after class. Well, wait a minute, what if the buyer is getting a home equity loan on a different house? Is that prohibited? No, because they're getting cash at the closing. They're not getting a loan secured by the subject property. But then that might not pass the test of what we talked about, proof of liquid funds before you even sign. I would demand proof of liquid funds even before you go under contract. That's what I would do. Wouldn't you?
I agree with you, but you're saying that you would put buyer cannot get a loan in the listing agreement
No,
or in the
no,
contract?
contract,
In the
contract.
Okay.
I'm just saying.
Wait, so let's take it a little further. So what happens if, for whatever reason, buyer doesn't have the cash and they need to get the loan? Then isn't that going to go along the lines of, well, we have to do what we have to do to try to get it closed? So then is the seller going to say, we said you can't get a loan?
They're in default. Yeah, I want your deposit. You're in default. That's a default. Getting a loan is a default. You said you wouldn't. That's what I would argue.
It's a really strong provision.
You're in default. You said you wouldn't get a loan. You are. You're in default. Let me give you my wiring instructions to give me your deposit. Yeah, that's what I would argue. But again, hopefully that wouldn't happen if you demanded proof of liquid funds before you go under contract. Of course, liquid funds can also disappear.
Of course.
You know, again, we're talking money here, folks, and anything can happen
I
when
just
you're
call
talking
it
about
dollars
money.
in the wallet.
Yeah.
You know, open the wallet, are
Right.
the dollars actually there?
So really, is it no more bogus cash deals with the new contract? As someone brought up, I'm not so sure. So I'm probably wrong here when I put in my little PowerPoint, no more bogus cash deals.
That was
I'm
at the
gonna
beginning. That
Yeah.
was like 2 months ago.
Exactly, page 21.
This is very-
I'm gonna have to amend that.
This is very fluid.
Yeah, it is. Now that this is kind of getting flushed out, I've got to take out on my top PowerPoint, no more bogus cash deals. I'm not so sure, I can't say that anymore.
I think we have 2 more.
I have a liability question. I have a buyer who wants to buy in one of these big developments in Naples. They have a contract like this. How am I liable? I mean, I cannot fathom explaining to this man what this 80-page contract is. They're going to sign it anyway. If they want to buy in there, it doesn't matter what I say in the first place.
That's right.
But how am I liable?
You're not in a position to explain it to them.
No.
So all you can do is tell them to see an attorney. If they don't want to see an attorney, then just tell them, okay, I advise you to see an attorney, go ahead and proceed. And the builder's in a position these days where they're not going to amend the contract. They don't have to. Demand is so high, they don't have to.
They were not even interested in explaining
No.
anything in there. They just give you this here.
My way or the highway,
Yeah.
and that's it. Sign, or we have 5 other people waiting. And that's why I hate markets like this. It's out of whack.
Yeah.
Just like all those short sales during the financial crisis, that was out of whack the other way. And I hated that market too. There's just, the markets are, when they're not at equilibrium, they're really problematic.
So there's something I've always done with that. Doesn't happen often, but in all the years, I make them sign something that that states specifically that they have been advised to talk to an attorney, that they fully understand, et cetera, and I make them sign it.
That's a way to shift liability away from you folks. And at the very least, if you get sued, your brokerage gets sued, you can point that out as an exhibit in the lawsuit saying, hey, I explained this to them, I told them to do it. Believe me, that's a defense. I'm not an attorney, I told them to see one, they signed it anyway. Your lawyer who defends you when your brokerage is sued is going to appreciate that. Is that it? All right. One more.
It's a little complicated, but not.
I don't know, we got time for complicated.
I'm gonna condense
Condense it up.
Article 11, ethics. Residential agents practicing commercial real estate. Most brokers, I've had it happen, I just had it happen twice in the past 5 years. They all think that their E&O insurance is going to cover the agent. I had a speaker from the insurance company specifically describing E&O insurance. Absolutely does not. Business brokerage is the biggest thing they're getting sued with right now. There's like a 20-page thing that has to get filled in, like mine, just to add that on top of the commercial in this picture. So brokers need to be aware that when somebody kindly tells you that your agent may not be covered under your policy, they really need to understand the policy and talk to their provider.
Okay.
Can I add to that? My E&O specifically doesn't like property management either.
Oh, yeah.
And I've received a phone call, a random phone call, but I suspect it may have been my own insurance company inquiring about rentals and so on and so forth. And I said, no, that's really a totally different business than what I'm in. I'm happy to refer you to someone who is looking for that sort of stuff. But I really focus on residential sales. So, but that was a little, I mean, and they don't advertise it to you when you buy the policy, what they don't cover.
Oh, they don't think you're going to read it.
Exactly.
Like the credit card agreement.
Right.
Don't forget to complete your broker survey. It's 3 questions that will allow us to bring to you topics and courses that are specific to brokers, so please complete that. Also, we'd like to take a group picture of all the brokers here today for our website. And if you would, Jim is here, he'll tell you where you're going to gather. It should take just a few minutes.
Great.
Thank you.
Okay.
Thank you.